Hello and welcome to SEO Daily. Today we bring you updates from the final day, that is day 16 in the hearings challenging the abrogation of Article 370. The day's hearing began with raised voices and tempers running high as Solicitor General Tushar Mehta opposed the affidavit filed by lead petitioner Mohammad Akbar Lone, declaring that his allegiance lay with the Constitution of India. Mehta insisted that Lone's affidavit declared that he withdraws the statements made publicly and that he does not support terrorist or any separatist activity. Senior advocate Gopal Shankar Narayan, in turn, pointed to the union's affidavit, which describes Lone's acts as pushing a separatist agenda. Shankar Narayanan raised strong objections to the Government of India taking the stance that filing a case under Article 370 was pushing such an agenda. The CJI stated, anyone who accesses justice under Article 32 cannot be turned out on the ground that they are following an agenda. He explained that as judges, the bench understands the anguish of the people who approach the court and that they knew how to handle it. The bench then firmly instructed counsel to come back to the merits of the case. Senior advocate Kapil Sibal resumed his rejoinder arguments. In the previous hearing, CJI D.Y. Chandrachud had pointed out significant silences in Article 370 on the status of Jammu and Kashmir and India once the slow integration was complete. Responding to that, Sibal argued that Article 373 is not silent on this matter. He stated that after the Jammu and Kashmir Constitution was drafted, the Constituent Assembly completed its constitutional task and set down a procedure for bilateralism in 371. He argued that this is further evidenced in the Presidential Order CO 48 of 1954, in which a proviso was added to Article 362. This proviso stated that no constitutional amendments concerning Jammu and Kashmir could be brought about unless the process under Article 371 was followed. Therefore, Sibal argued, there were no silences left to fill, except that of the people of Jammu and Kashmir who were never consulted when issuing CO 272 and 273. You'll remember that these are the two presidential orders that ultimately abrogated Article 370. Senior advocate Gopal Subramanian argued next and dealt with the Chief Justice's question of whether there is evidence in the Indian Constitution that the J&K Constitution was applicable to India. Subramaniam said that the first evidence is in the text of Article 370 itself. 370 Clause 2 refers to a Constituent Assembly of Jammu and Kashmir formed for the purpose of framing the Constitution. Here, the provision is seen clearly alluding to the Jammu and Kashmir Constituent Assembly. The second piece of evidence, he said, is that Part 6 of the Constitution, which concerns the functioning of state governments, was rendered inapplicable to J&K. This, he suggested, is evidence that the Indian Constitution cognitively takes note of institutions such as the legislature, executive, high courts, etc., as set up by the Jammu and Kashmir Constitution. Chief Justice D.Y. Chandrachud then asked, is it that the Jammu and Kashmir Constitution is subordinate to the Indian Constitution? He said that there was also no evidence to argue that the Jammu and Kashmir Constitution was even at par with the Indian one. This is because the applicability of the Indian Constitution and the demarcation of power of the Parliament were both made by the Indian Constitution itself, bringing the Jammu and Kashmir one squarely under its wing. Subramaniam agreed that the Jammu and Kashmir Constitution was not superior, but it could not easily be considered inferior because all the establishment of the institutions and their genesis derive legitimacy from the Jammu and Kashmir Constitution, not the Indian one. Subramaniam contended that the Indian Constituent Assembly gave a sense of space and sense of choice for the people of J&K to decide their own fate. Senior advocate Zafar Shah, who was the only lawyer from J&K to argue in the rejoinder, said that to call the Jammu and Kashmir Constitution inferior was not palatable to its people. In fact, he said, the J&K Constitution was on a better footing than the Indian counterpart, since it was drafted by a democratically elected Constituent Assembly. India's Constituent Assembly, in contrast, had been elected by provincial assembly members through proportional representation. After the presidential order of 2019, the ocean of autonomy that J&K retained was reduced to a pond, Shah said, which led to the people of J&K losing their identity. Why can't the Union of India accept that there can be two constitutions, he asked, while saying that self-governance is better than good governance. Senior advocate Rajiv Dhawan appeared next. On day 15, the chief had asked if Article 370 was above the basic structure because petitioners had claimed that it could not be amended under Article 368. On day 16, Dhawan clarified that they had not challenged the abrogation on the grounds that there were limitations under 368. Rather, the abrogation had violated the constitutional rights of people of Jammu and Kashmir. That's one way in which basic structure entered the conversation here. Lastly, the bench heard arguments from senior advocate Dinesh Dwivedi, who argued that the union had wrongfully relied on Mohammad Maqbool Damnu versus State of Jammu and Kashmir, which is a 1972 case, to justify the use of Article 367. The facts of that case were different and did not make substantive changes to the constitution. The only material to the president to abrogate Article 370, he said, was consultation and concurrence with the state of Jammu and Kashmir. After Dwivedi's arguments, the court erupted with overlapping pleas and requests by a sea of advocates who wanted a few minutes to add to the rejoinder. After 16 days of hearings, the bench sternly ordered all other counsels to submit their rejoinders on paper. With this, 16 days of hearings in the challenge to abrogation of Article 370 concluded. Make sure to watch all the episodes of SEO Daily where we break down the complex arguments made by the 40 lawyers in this case. We also invite you to write to us, either in the comments below or to admin@seobserver.in with your thoughts on the case and any feedback on our coverage. Thank you for watching.